fighting natural gas drilling, infrastructure, injection wells, also things like toxic waste, coal mining, you name it, stuff that people don't want coming into their communities. I'm going to give a little bit of background on our organization and talk about how communities are resisting those projects these days by asserting their fundamental rights to local self-government, to be the ones that determine the future of their community. So I think I'll try to get through this quickly, then just open it up to Q&A for folks, and then we'll move from there. So thanks. I always enjoy coming into a meeting and seeing beers and wine on the table. I know it's a good group of people. First quick disclaimer, I'm not a lawyer, even though I work for a law firm. No offense to any lawyers in the room, but I get accused of it and I take real offense from time to time. So I'm not a lawyer, I'm not offering you legal advice tonight. The work that we do now is very, very different from what we started out doing. We opened in 1995, a little bit before my time, as a nonprofit public interest law firm to provide free legal resources to communities across Pennsylvania who are facing industrial threats to their health and safety. That time it was a lot of things like factory farms, big 50, 60,000 head hog factory farms, the dumping of sewage sludge on farmland, all this stuff that the communities didn't want. Our executive director and co-founder, Thomas Lindsay, came out of law school, and what he was taught in law school is what environmental lawyers are still taught, is that we have the best environmental laws in the world in this country. We have the best environmental laws in the world. We actually export them to other countries that they can model their own legislation on. So as he came out of law school and saw all these harms being forced on communities that didn't want them, he said, well, if our laws are so good, then why is all this nasty crap getting stuffed down people's throats that really don't want it? Why can't they just say no to this stuff? So he opened the Legal Defense Fund to try to plug that gap, basically. Well, if we've got such great laws, we must just need more lawyers that can enforce those laws. And we also need free lawyers to provide the services to mostly rural, poor Pennsylvania communities who often don't have the money or resources they need to hire their own counsel. So we opened the Legal Defense Fund basically to plug those gaps, to enforce the environmental laws and to do it for free to communities that needed the service. What that looked like, and it's still very much the same today in a lot of cases, is we'd get a call from a very frantic person on the other end of the line. They'd say, this thing is coming in that we don't want. We need you to help us. We would say, we can do that. And what that looked like is a conventional, traditional environmental law firm is we would go in and we would work with the community to appeal the permit that had been issued to allow the activity to take place. So as we all know, the pipelines, the injection wells, the fracking, factory farms, sewage sludge, all of those things are issued, all those activities are issued permits by relevant state or federal permitting agencies. So at the state level in Pennsylvania, we have the DEP, the Department of Environmental Protection, Department of Everything Permitted, as most communities I work with call it. EPA at the federal level, a lot of things with the pipelines right now that cross state lines. FERC, the Federal Energy Regulatory Commission, that's the relevant permitting agency. So all these activities are issued permits, and the permits legalize a certain amount of harm to go along with that activity. You have a permit. This now permits the activity to happen, and it permits a certain amount of harm to take place in association with that activity. That's what the permitting agencies do. They issue permits to legalize harm associated with activities. So what we used to do, and this is still what most major environmental organizations do today, is you would work to try to appeal the permit on the assumption that if you can get the permit tossed, i.e. if you can convince the regulatory agency that this is a bad idea for this community, then without that permit, that activity can't take place. So you work to find the flaws and the deficiencies in the permits. How many folks in here have looked through permits before? Sorry, I'm sorry. You know, you pretty much measure by the pound and you look through these things for what's wrong with it. You know, and so our job was to find flaws in the permit, like they put up the wrong bond amount, or their wetland study was 10 years out of date, or their traffic study didn't take into account new trucks that are coming on the road, or all this stuff. We find this list of flaws and deficiencies, haul it before the judge, the community group behind us, and say, Your Honor, this activity can't proceed. The permit is flawed and it's deficient in all of these ways, so it's got to stop. By and large, the judge would agree with us, in general. And say, you know what, you're absolutely right. All of these things are required by the permit application to be there. They are not there, and because they're not there, the permit cannot issue. So he would toss the permit, and we'd go back and we'd sit around tables like this with the community group and have beers and snacks, and everybody would congratulate each other and say, you know, the system worked. We did everything right. We appealed the permit, we got the law firm involved, the judge agreed with us, and now we're not going to get the factory farm or the fracking or the drilling. As you folks probably know, what happens 3 months, 6 months later, the corporation resubmits the permit application, and this time they will have filled in all the flaws and the deficiencies that we had identified for them. We actually had corporate lawyers thanking us tongue-in-cheek in the courtroom saying, hey, you know, thanks for helping us to build a bulletproof permit. Weren't even costing them money because they get to write off the costs of fighting the permits as a cost of doing business on their tax returns. So, you know, 3 months, 6 months later, the corporation would be back, they would resubmit the permit application, the community group would call us up again and they'd say, hey, whatever you did the first time, we need you to come and do that again. Because even though it's 3 months later, we still don't want the sludge, we still don't want the factory farm. You guys are the experts, meaning us, so come in here and do whatever it is that you did and get this permit tossed again. To which we found ourselves having to explain to them that we had no other levers left to pull legally. The legal language is administratively complete. If the permit is administratively complete, meaning all the I's are dotted, the T's are crossed, all the stuff that is required by the permit application is there, if it's complete, then the permit shall issue. It has to issue as a matter of right to the corporation. It shall issue. The regulatory agencies do not have discretionary authority when it comes to issuing the permits. Whether they think it's a good idea or not, it doesn't matter. As long as the permit application criteria is met, they have to issue the permit. Somebody mentioned Groundhog's Day a little while ago. That became Groundhog's Day for us, living the same day over and over and over again of working with these communities to try to fight these permits that had been issued, but in the end, the permit still ended up being issued and the community ended up getting the activity that they didn't want. This is still what mostly plays out in most environmental fights today. You look at it in Pennsylvania, across the country. Most folks that try to fight this stuff through the permitting arenas, fighting the regulatory agencies and trying to get better permits, end up getting the project. At best in the regulatory system, you're left trying to get harmed a little bit less. Maybe you negotiate greater setbacks, or maybe you negotiate, some renovation of another wetland in your community to offset the one they're going to harm. Maybe you negotiate the hours that the trucks get to come through. It's not about stopping the harm, it's about limiting and regulating the harm that's taking place within the community. That's what you're allowed to do in the regulatory system. To which, after a couple of years of this stuff, communities started asking us a very simple question. Because they would have us back on the line and say, look, we want to stop this thing, so come in and do whatever it is that you have to do. And we say, we can't. We have no legal levers left to pull. To which they ask us a very simple question of why. Why can't we just say no? We have guys in rural Pennsylvania pulling out copies of the Pennsylvania Constitution, Article 1, Section 2. All power is inherent in the people. It's what we've been taught since we've been in grade school. We have the greatest democracy that's ever been conceived of anywhere in the universe. And we have consent of the governed. So they would say, if we have all these great things that we're told we do, why can't we just come together as a community and democratically decide that we don't want the project and just say no? Why do we have to become experts on all of the science and all of the geology and all that stuff? Why don't we just say, we think this is going to harm us, we have the authority to say no, and let's do it. That began the evolution of our work. We began about a 5 to 10 year historical research project where we went back to the Magna Carta and looked at the history of our legal and political system in this country. Has anybody in here been to a democracy school? A couple folks. We do these weekend seminars. We're doing one this weekend down in Lancaster County where we actually trace the history of the legal and political structure in this country and find out why it's so difficult for people to democratically make decisions these days. There's a long sordid history of how this came to be. The long and the short of it, and just to get through this quickly, is there's a number of legal doctrines that bear down on us in our communities right now. Things like preemption, folks have probably heard of that, either state or federal preemption, where the state government or the federal government pass what are called preemptive laws that remove any authority from our communities from having a say over particular issues. So when it comes to fracking, you're going to hear that the state's preempted you from deciding on that. When it comes to pipelines, you're going to hear that the federal government and FERC have preempted you from having any say over that. When it comes to sewage sludge, that's a state issue. The state's preempted you from deciding whether or not you get to spread sludge in your community. They passed preemptive laws removing authority from our communities on these issues. Another issue probably familiar to folks in here is corporate rights. That corporations have constitutional rights as persons. So corporations, like Williams Corporation or Chesapeake Energy or whoever else you might think, they have corporate constitutional rights under the First Amendment to free speech. They have constitutional rights under the Fourth Amendment to be free from unreasonable searches and seizures. Under the Fifth Amendment, they have rights to due process and to be free from governmental takings of their property. They have Sixth Amendment rights to face their accusers in a court of law. They have 14th Amendment rights to equal protection. All of these things that were originally intended to apply to folks like us around the table tonight have now been bestowed by courts on corporations. All of that may sound kind of academic and weird and maybe a little ridiculous, and it is, but what it means is that 7 people on a corporate board headquartered in Oklahoma or California can have more authority and say than a majority of people living in your community. If you try to keep out a drilling corporation or a Walmart or anything that you might be concerned about, they can sue you under the 14th Amendment, which is supposed to apply the law equally to all persons. It was passed after the Civil War to make sure that the law applied equally to blacks as well as whites. Corporations now have 14th Amendment protections, and they will say, if you try to keep us from coming into your community and putting this drill pad in there, then we will sue you under the 14th Amendment because you're not applying the law equally to us. You are discriminating against us. We could go through cases like this all night. It would be very depressing. I don't think anybody wants me to do that. But again, the short of it is that 7, 9, 11 people on a corporate board can use these rights against what 5,000, 10,000, 15,000 people in your community may want. The last piece of the puzzle, I sometimes draw an outline of a box and talk about the box that our communities are within in terms of these legal doctrines, is what we call around the office the regulatory fallacy. And this is the idea that's been implanted in our brains since the 70s that we actually are able to get what we want in our communities by using the regulatory system to our advantage. The communities we work with have given up on that. They've stopped believing that the regulatory system is actually there to protect our communities right now, and they see it as a system which actually legalizes harms associated with activities. A lot of folks, scream, why don't we just have better regulations? We see more or stricter regulations, whatever it may be. Well, the regulatory agencies are functioning exactly as they were intended to. They were actually requested by corporations because they act as a barrier between the corporations and the people. We yell at the DEP or the EPA, not the people that are actually doing the harm. So from our perspective, trying to work through the regulatory system, that was where we started in '95, and we still watch most major environmental organizations do that today, doesn't actually get communities what they want, which is democratic decision-making authority to determine the future of their communities. You end up having to put your lives on hold for 5 or 10 years and become experts on all aspects of the drilling process and all the chemicals and all the stuff that's going in the roads and watersheds and all this stuff that's good to know. But I don't think you folks have teams of lawyers and lobbyists that are lobbying the regulatory agencies and our legislators in Harrisburg or DC to get whatever you think would be good regulations implemented by the DEP. You're usually up against a very wealthy machine that has engineered these regulations to roll over your community at the first sign of resistance. That's why it's so hard to stop it if we work through the system we've been given. To which, pardon my French, was we explained this system to ourselves and then to the communities we were working with. You had these old farmers in South Central Pennsylvania said, well, if what you said is true, if that's actually the truth, that's bullshit. That goes against everything we've been taught, against everything we think we believe, and we would be foolish to continue banging around inside of this system that doesn't actually provide us any meaningful remedies. We've tried it for 40 years. Once in a while we think we get a win where we've kept out a Walmart or a drilling project, but we didn't actually stop it. All we did was we put enough of our money and our lives on the line to make it difficult enough for the corporation to come in that they just went next door. But we didn't actually say no, and it doesn't mean that they can't come back again at some point in the future. And maybe right now it's drilling, and maybe next year it's a pipeline, and maybe in 3 years it's an injection well, in 5 years it's something that we haven't even heard of yet that we don't want. But we never actually have changed the system to make it any easier for us to protect our communities, working through the regulatory stuff over the last 40 years. So they said, that's bullshit. Why would we continue asking the system for remedies? And that's when they asked us to start doing the work that we now do, which is, they said, if we're going to have an argument, if we're going to have a fight, if we're going to have to go to court about this, or if we're going to have to talk about this in public, let's have it on our terms, not on the terms that the corporations have set up for it. Let's have set up for us. Let's have it on our terms, which is about rights, which is about who decides what happens here, who determines the future of our community. Let's actually pass a law that prohibits the project and base it on our community rights to self-government. So if we're going to have an argument, the argument's not about where the well pad is going to go or how many trucks. The argument is about who has more say here. 7 people on a corporate board, or the majority of people who live here and work here and raise their families here. Let's have that conversation in public and in the courts. That was the work we started doing in the early 2000s. There's now over 100 communities across Pennsylvania that have passed some version of these rights-based local ordinances that prohibit activities from fracking to pipelines to injection wells to factory farms, toxic waste. That's in Pennsylvania. Across the country, there's close to 200 communities that have passed some version of local laws like this, banning harmful activities. That's a lot of my work right now. I know folks in this room were interested in what kind of stuff we do. A lot of times communities contact us about these single issues, and then I work with them or the community group to write up ordinances, which they can then try to pass in their communities that would prohibit the proposed projects. You recognize in taking this stuff on that it's about stepping outside of the box that you're in currently in your communities, and about actually challenging the legal structure and the legal system. The communities I'm working with think it's unjust that corporations have more say than a majority of people living there, and they're willing to actually stand up and challenge that. That could be inviting a lawsuit. For communities we work with, if they pass ordinances we draft with them, we offer pro bono legal services to aid in the defense of that ordinance. But just to be clear, you're stepping into uncharted territory in some ways. The charted territory is very clear on what will happen if you try to stay within the regulatory system and work with the options you've been given. Couple of other quick things. Home rule. Some folks ask me about home rule because a lot of the criticism I get for the local ordinance approach, especially in second-class townships in Pennsylvania, is that, well, our supervisors are never going to pass something like this. They don't want to open up the township to risk, to liability. They don't really care about the concerns of the majority of the community anyways, so they're never going to pass a local law like this. There is a provision under Pennsylvania municipal law which allows people to actually gather signatures on a petition in their community and put something up for a vote of the residents of the community. It's not actually putting the issue itself up for a vote at first, so it wouldn't be saying, do the people of this township want the pipeline, yes or no? What happens first is you actually have to change the form of your municipal government from a second-class township or whatever type of municipality you live in to what's called a home rule municipality. Home rule allows you to go around your elected officials and actually put something up for a vote of the residents. There's only about 65 communities in Pennsylvania that have gone this route. That's out of about 2,500 total communities. And the reason more communities don't do it is because it takes some time and it takes some energy. It's 2 election cycle process. So the soonest that you could get a new home rule charter in your community at this point would be the November 3rd election of this year. There would be an election in May and then another election in November, and I can get into all the details for folks that are interested. But just to say, there is a provision. It takes time. You need a core group of people to do it. But it is possible to actually get something up for a vote of the residents of your community if you find that you're not able to budge your elected officials in the manner that you want them to go. So I'm going to leave it there for now. It's a lot, and just say that we are assisting a number of communities right now with doing home rule campaigns for this year. And there's continued ordinance drafting going on as well. So it's all uphill, as you probably know. But the question is whether you want to try to get what you want within the system you've been given, or if you think that you really don't have access to get what you want in the system as it is, and you're willing to challenge it and step outside of it and work on a different platform. See a question in the back.
What percentage of population do you have to get to sign on to get it onto the ballot?
So the first question that would go up, and that would be on the May 19th election of this year, is the primary election. And that question is, do the people of such and such township want to consider forming a home rule study commission? And what that study commission would do is actually take a look at the existing governmental structure you have as second-class township or whatever your municipality is, and say, all right, these things are wrong with it, and this is what we want to propose. So to get that question up in May, you need signatures from 5% of the people that voted for governor in the last gubernatorial election. So the November election last year, you need signatures from 5% of the people that voted in that municipality. I heard, is Plunkett's Creek?
I was going to say, yeah, I'm in Plunkett's Creek, so is Karen and Rob. And yeah. I asked them, I went there at 5 o'clock on election day and asked them what percentage. I think we have about 663 or 668 registered voters. And it was about 143 people had come in, and polls were only open. I'm sure they may have gotten.
Exactly. It's a very. The signature threshold is very. The signatures are easy.
I'm sorry, let's just run through those numbers again. You said 143 people.
I think it was 140 about 5 o'clock.
5% of that.
5%?
Yeah.
98.
That's the easy part for the first phase. The hard part is getting at least 7 committed people who would be willing to sit on that government study commission.
Oh, but that's not, we can get that easy.
And those are people that would basically need to be committed for about the next year.
Oh,
I'm gonna
we
run-
got that.
I'm
run
sorry,
through-
what was the number you said?
You need at least 7
7.
people who would be
7?
willing to sit on the government study commission.
Oh,
So
we got
essentially, I'll run through the process very quickly. It seems like there's interest. The soonest you can start gathering signatures on the question about whether or not the community wants to consider home rule started December 30th. You have up until February 17th to gather that initial signature threshold of 5%, which sounds like would not be a problem. From February 17th to March 10th, and I have all the calendars for everybody that wants it, that's when the at least 7 study commission members would also gather signatures. And that requires only 2% of the people that voted in the last gubernatorial election, so 5 signatures or something. And so, but those 7 people essentially actually run and campaign to sit on the study commission. And their names would also be on the May ballot. If you have opposition to what you're doing in your township, it's also possible that the people who are opposed to what you're doing would run their own candidates. And so they would also be gathering signatures in February and March. So you need at least 7, preferable to have 8 or 9 if you have people drop out or whatever. They may also be running candidates, and then you come up to the May ballot. And you essentially run a political campaign, if you want, up to the May point, where you're saying, this is why you should vote for home rule, this is why we need it, these are the benefits it's going to provide to our community, these are the reasons that we haven't been able to get what we want, all this stuff. On the May ballot, people vote either yes or no as to whether or not they want to consider home rule. And if they vote yes, then they also cast votes for the study commission. And then the top 7 vote getters out of all the people that ran for study commission are the ones that would actually sit on it in the summer months. So to say that it's important to actually get your word out, because if you have opposition candidates that run against you and then they staff the study commission, then you don't get what you want. The study commission would meet, if it forms, in the summer months, basically June, July, and August. You can do as little as you want. I think the minimum amount of meetings would probably be 6 to 8 during that time to do all the studying and the writing of the new charter. You can also go hog wild. We worked with a community a couple of years ago in Washington County, Blaine Township, that actually wrote an entire new constitution for the community, dealing with sustainable ag policy and waste policy and pretty much anything you can think of. But you can do as little as you want to. You can basically say, we want to keep everything in our township the same, including our board of supervisors and whatnot, except we want to add initiative provisions so that we can have a vote of the people on this stuff. We want to add recall provisions so we can recall our supervisors if we want. And then you want to add whatever, rights and prohibitions, whatever it is you want to stop. So that's the, minimum amount would be 6 to 8 meetings, and then you would have to have your charter drawn up and finished by September 1st for submission to the Board of Elections to go on the November 3rd ballot. So all that stuff is just kind of the nuts and bolts. It's relatively easy. We've handled all the petitions for communities in the past. We'd be happy to work with you folks on some of that as well. It's just, finding the people and finding the will to say this is what we want to do for the next year of our lives.
That's all we do.
First of all, I want to apologize, especially to you, Chad. I didn't know you were here. I was out front waiting for you.
You're drinking?
I was here 20 after, but I had to come back here. So thank you for starting things off here. One thing that I'd like to throw in, and you may want to consider this as sort of like a selling point, especially in an area like this, which is predominantly a conservative area. When you look at conservative principles, local control, home rule, smallest form of government, is one of the core conservative principles. Mm-hmm. So, what you're asking the people is, do you want a larger government, do you want a state government, federal government to dictate how you're going to live in your community, or do you want that smallest form of government to prevail and have a voice in it? And surprisingly enough, the more conservative people are in their thinking, the more likely they are to actually go along with that. Another thing that I would just like to expand on is Chad was talking about the corporate rights versus, their personal rights versus the rights of the people in the community. One of the things the corporation seems to stumble on, if there is such a thing, you know, if it does go to a lawsuit, they sort of have to explain why their personhood rights should outweigh yours, why their rights mean more than yours. And that opens a whole different can of worms for corporate personhood, and that's something that they don't really want to address either. They don't want that to become redefined.
Have any of the ordinances that you've helped get passed been challenged in court?
Yep, we have ongoing litigation right now in 5 states. There's one currently being litigated in Pennsylvania, Grant Township, Indiana County. They passed a community bill of rights ordinance earlier this year banning injection wells in the township, so the injection of fracking waste. They got sued by Pennsylvania General Energy Company, who then hired a slick law firm out of Pittsburgh to represent them and sue this small rural municipality of about 600 people.
Perhaps in Calvin?
Yep.
Yep.
Where was that again?
Where? Grant Township,
Grand
Indiana
Township,
County.
thank you.
So that's currently being litigated in federal court. We'll probably get an outcome later this year. Those folks are considering home rule right now as well. They're still right now a second-class township, but are considering trying to do home rule for an extra layer of protection. Other litigation, there's federal lawsuit right now against the county we worked with in New Mexico that banned fracking. One in Lafayette, Colorado, that also banned fracking. They got sued by a drilling association. And then in Ohio, there's active litigation as well against the community that banned drilling. And then we have some ballot access stuff going on in Washington where a community actually gathered signatures to put something up for a vote, and then the corporation tried to keep it from going up for a vote, and so we're doing ballot access stuff up there. I think probably the next part of the question is, have we gotten any judgments or returns on these things?
Especially in Pennsylvania.
Right. No. There's been a few lawsuits we've dealt with over the years, and there were 2 examples where communities had passed ordinances prohibiting a project. They got sued by the corporation, and then the supervisors basically got scared, and they just went ahead and repealed the ordinance in order to even out the lawsuit. Those communities still haven't gotten a project, but they basically decided not to go on with the legal stuff. In Blaine Township, one of the home rule communities I mentioned, they got sued by a coal corporation over a community bill of rights ordinance that they had passed, I think it was 2006. There was a negative judgment in the Western District of Pennsylvania federal court, but they had actually repealed their ordinance at that point because they were going home rule. So they repealed the ordinance before the judgment came in. The judgment still came in, but that's not precedent setting. And also the current versions of the ordinances that we do are much different than the one that was in Blaine. So the current stuff that we're doing doesn't have a legal, like, precedent setting stuff in Pennsylvania at this point. It's not to say there won't be, and we're always very clear with communities about this, which is that you're challenging well-settled law. That for the past 150 years in this country, corporations have been seen by the courts to have all these rights against what the communities want. And so, you know, we're pretty clear with folks that when you engage in this litigation, you may not get the outcome that you want because you're asking the judges to overturn 150 years of jurisprudence. And that's why, from our perspective, it's very critical that more and more communities do it to keep forcing this change upwards. I mean, that's how the civil rights changes happened. That's how the suffragists and the abolitionists did it, is they all actually challenged the law at the local level first. I mean, you can look at, the suffragists had over 450 different actions where they opposed the laws that were in place, including passing local laws that gave women the right to vote. So they actively challenged the law hundreds and hundreds of times before they got the changes they wanted. And I'll just say a last piece of this puzzle from our perspective, and it's something I haven't talked about yet, but we now have state community rights networks, as they're called, in 7 different states across the country, which are focused on actually taking all the single issue harms that we're talking about and that you folks might be concerned about. How do we take all that energy and actually begin to move that into a statewide movement that can drive for constitutional change? Actually change the Constitution to work for our communities and not for corporations. So that's also one of the, you know, regardless of what the outcome is in the courts at this point, there's also people actively working, including John, on doing the statewide constitutional stuff to actually free up our communities and legalize these ordinances. So it's a pretty complex picture what's going on out there. It is important, you know, in terms of what the courts say, because they're real judgments. If the courts come down against a community rights ordinance and they strike it down, that ordinance is suspended. The communities at that point have a decision to make whether they're going to legitimize or agree with that judge's perspective, or whether they're going to pursue other options to keep the activity out. And I'll give you a quick example of what that looks like, because I think it's important in terms of how people see the courts in all of this. State College, Pennsylvania, not too far from here, they are a home rule municipality. A couple of years ago, they passed an amendment to their home rule charter that banned drilling and related infrastructure in the borough. Last year, Penn State decided they wanted to transition their existing coal-fired power plant over to a natural gas-fired power plant. To do that, they were going to have to run a 12-inch gas main over to the existing coal-fired plant. They, instead of running it through their own property because it's dangerous and they didn't want to disrupt all their infrastructure, they decided to run it down a right-of-way on a residential street running through the borough. Community group organized and said, we're glad you think you might try to do this, but we have this community bill of rights in place that says right here it prohibits pipelines. So, sorry, you can't put it down our streets. They said that to Penn State and to Columbia Gas, who is the contractor. Penn State and Columbia Gas came back to the community group and they said, we're glad that you think that this law is going to work, but look, this local law you pass is basically boutique. It's not enforceable. We've got the state permits. This is a state issue. You're preempted from doing this. All this stuff that we talk about. You're preempted. You can't do it. And so, we're glad that you made your voices heard. We're glad that you passed this law. It's not enforceable. We've got the permits, so we'll do our best to work with you to make sure that this is the safest pipeline that's ever been, put down anywhere in any galaxy ever. We'll work with you, and so here we go. So this turned into 400 or 500 person borough council meetings, and the community group came back and said, no, actually, I don't think you understand. This is a law. This is a law. We passed it. 72% of the people in this borough voted it in. They approved it. It's enforceable law. It's on the books. And you, as corporations, both the university and Columbia Gas, you don't have the authority to decide which laws you want to follow and which ones you don't. So, it's on the books. We don't understand what you're not hearing, but, the pipeline's not coming through. It's law. To which the corporations then said, fine, we're just going to sue you and get this overturned. Clearly, this is going to be overturned in the courts. This is an illegal use of municipal legal authority, and, any judge is going to overturn this probably almost immediately and all this stuff, trying to threaten the community. They said, look, to be honest with you, we honestly don't care what the judge says, because the judge doesn't have any more authority than you corporations to violate our rights. We passed a law that protects our rights. That's why we have governments, whether it's the federal, state, or the local. If the federal and the state levels of government are issuing policies that violate our rights, then the duty falls to our local government to pick up that slack. And that's what we did. We passed a law that protects and asserts our rights, and we intend to enforce that law. So even if the judge decides he wants to overturn it and he thinks he has the authority to violate our rights, we will physically be stopping you from putting this pipeline through our neighborhood. It's not coming through. We don't know what you don't understand about this, so move along. And they did. They forced Penn State and Columbia Gas to back down. There was no lawsuit, but citizens actually took that conversation public, decided they were going to enforce it, and they did. And the pipeline didn't come through the neighborhood. So just to say an example of what this stuff could look like down the road. It may not mean the court's giving us the remedies that we want at first. It may mean people actually doing what has been a long history in this country of people who were denied their rights and actually had to stand up and fight for them and assert them. And if you don't, they're assuredly going to be violated at this point.
So they were threatening civil disobedience to prevent this from happening?
Yep.
And in that case, University Park, the Penn State was not part of the municipality. They are a different entity.
Yeah, they're part of it, they're part of 3 different municipalities over there. And they like to keep their true decision-making authority hidden. Nobody really knows, are they public, are they private, who governs them, all that stuff. So, but from the community's perspective, they were protecting the borough neighborhoods themselves. That was what they were fighting for.
Unfortunately, that means Penn State is still burning coal.
Yeah, there's downsides to all of this. I mean, and that's a lot of, we get that a lot of times. Well, if you stop it here, then it's just going to force us to go somewhere else where we maybe stay reliant on other things. But I don't know if, burning gas is any of a better thing.
I think they're almost completely off of coal. They've made the transition to gas anyway.
Okay. But that's a common, I don't know if that's your criticism, but a common criticism that's levied against communities that stop these things at first is, well, if you want to stop this, you're just going to force it somewhere else, or you're going to, continue to, make sure that other people get harmed. And so, what's your alternative? What do you have in mind as an alternative here? If you want to stop the drilling from coming in, do you heat your home with gas, or, all these things where they basically try to make people feel bad about even standing up and having a voice. And the communities I'm working with are saying, look, you didn't care about our perspective before we actually stood up and decided we wanted to engage in this conversation. So, we didn't make the energy policy decisions for the last 40 or 60 years in this country. You can't look to us and expect us to have every single thing figured out about what's the next 20 years of energy, infrastructure is going to look like in this community. We're feeling like our rights are violated right now. This is where we're going to make a stand, and this also gives us a position where we can move forward in the future with more sustainable infrastructure as well. So it starts here with the saying of the no, and then that actually gives us the platform we need through this local law to move towards other more sustainable yeses in the future too.
And they
So.
are, that group.
Yep.
So are you saying that home rule preempt state and federal law?
The state and the feds would say that they would preempt home rule. So whether you pass an ordinance or whether you're a home rule municipality, the state government right now would still say that you're preempted from doing things related to gas infrastructure, for example. They would say you can't do that, that's preempted by the state.